But under the promises from the state.
What are the legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection? Where is that a change in the deposition? No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it and find.
Let's just reread the entire proffer, just so that it's a clear soup to nuts, alpha to the omega. I specifically asked you, Mr. Owens, to point out for me excuse me, I am not going to read an 87-page deposition and continue to waste our jurors' time.
I move for a total dismissal for prosecutorial misconduct.
Denied.
Reflect on a lot of these opinions, so
That's respectfully, sir, that's not what it says.
Why would I take her deposition when she hasn't finished?
Because the court ordered you to take her deposition. But the citations, respectfully, counselor.
If I could finish.
Respectfully, counselor.
Can I read a little bit more?
If you're just going to be reading from the treatise, I've already read it.
Okay, well, I just want.
It was a volatile relationship. In the police report, her ex-husband actually describes her as being the aggressor.
Today was a really bad day for the defense, in my opinion. Now, we're going to start with Dr. Tanya Werner. So at this point, the defense has rest. Now it's the state's turn to put on their rebuttal case. Dr. Tanya Werner is going to be the psychiatrist who evaluated Sarah Boone, met her for about 2.5 hours, and she is going to rebut the testimony of Dr. Julie Harper, who was the psychologist that testified yesterday.
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work. So controls their ability to make money or access to funds, so they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence, and end up having this syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And can this element of control come from controlling personal items such as identification papers?
So we've seen the body cam before. I don't know if it's going to be different than what we've watched on the live stream. I know that Mr. J is trying really, really hard to paint that George was also the victim and that George was also on the receiving end. I think like Mr. J needs to do a really good job at acknowledging, Sarah's abuse. And then when talking about George's abuse, I think at this point, it might be hard for the jury to acknowledge Sarah abusing George because they've seen all the evidence of Sarah's injuries. So I don't know if we're going to see George's injuries, if they're going to be like bad as well, if there's going to be like multiple instances. Like I feel like whatever happens after this witness, Mr. J is going to have to do a really good job at showing, okay, well, George was also being abused by Sarah and this is how bad it was. Because after seeing those pictures of Sarah and how bad they were, the jury might have a hard time kind of identifying George as also someone who was a victim in the relationship. Do you guys get what I'm saying? I'm not saying that George is not, but I'm saying that to convince the jury, right? So we have seen different sides of Sarah, right? I mean, I know they've seen the body cam, the interrogation. They know how she was like that. But we've also seen like the letter side, right? The talking shit about the attorneys, the personal attacks, the accusations of Judge taking money and stuff like that. We've seen like the whole crazy side of Sarah Boone. The jury, they haven't seen all that shit, right? Because that's that's not in the trial. It's not in the trial. It'll be too prejudicial. But I think if Mr. J is going to convince that to the jury that George is a victim, it's hard with all those pictures. So I hope, maybe we'll see some pictures and all this stuff, but like the jury might not be buying this is what I'm saying.
Papers
Yes, absolutely.
can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's.
Yeah, I think if he's able to get Brian Boone and have Brian Boone talk about his experience with Sarah, that'll be a huge one. But when they were talking about scheduling yesterday, they didn't mention Brian Boone. They just said she was going to testify and there's going to be some 2-hour body cam. And I didn't hear Brian Boone in there. I don't know if they're allowed to talk about, and I don't know if they're allowed to have Brian Boone to talk about. Like, I don't know if that door's already been open, but it seems like to me, I don't think they can talk about Sarah and her past history and all that stuff at this time because it would be too prejudicial for her. I think there might be I thought the door would open when battered spouse syndrome was introduced, but I think I might be wrong. I'm just trying to think from the jury's perspective. Like if I was only exposed to everything that I've seen in trials so far and like our lens are like very, very focused and narrow, and you haven't seen all the other shit that Sarah Boone has done, you might really buy that Sarah's the victim and the only victim in the relationship.
Is because he or she paid for it, even though it was a gift.
Yes.
And in this particular case, were you asked to do an evaluation of Sarah Boone?
Yes.
What date did you have an evaluation of Miss Boone?
It was early in October, I believe October 2nd.
What did she indicate occurred on February 23rd, 2020 to you?
Right. Is it all right if I refer to my notes just a minute?
Just if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she went downstairs and indicated that she had found him, and they were kind of laughing, and she zipped the suitcase up, and they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her, and she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
If you refresh your memory, just
Yes.
put them down and then tell us what you remember.
Yes, that is the inconsistency with Sarah Boone's story. I think initially she told people that she drank at 4, and then we heard after 12, we heard noon. We heard, because the Publix receipt at noon was like at 12:17, I think. We heard that it was like shortly afterwards. So the story is all over the place in terms of when they started drinking. I guess depending on what period you asked her. No, because they have to testify from memory. They can't just sit there and read the report. She's supposed to have it memorized, and then if she needs to refresh in her memory, she can refer to her notes, but she can't just sit there and just like read from her notes. No, she can't do that. Let's see. Oh, when someone's nervous, when I'm really nervous, I say a lot. Or if I'm really stuck on something and my mind is working really hard to get my cogs working, the thing is really hard, especially when you're testifying, man. You're probably nervous as hell. No, the jury, they do not get the reports because they're hearsay docs. I know they could be entered into evidence and they could be referred to, but they are not supposed to be getting the reports unless things are differently in this court system. But that's what I remember from the previous trials that I've covered.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out and her son's baseball bat was sitting there and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
Do you guys remember when she was showing with the suitcase, there was a demonstration where she was in the well and Mr. J asked her, where were the 2 zippers? And it made it seem like the zippers were pretty far away from each other. It looked like there was enough room for George to probably stick out his entire hand, not 2 fingers, but that wasn't brought up as well by Mr. J. I think it was good to show that Sarah Boone struggled with the zipper. I think that was really good because it's like, well, if you struggle this much with the zipper, how did you expect George to get out? Being on the inside, right?
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about...
Judge, if you could approach the bench.
Yes.
Okay, this is going to be a long objection. They have a sidebar. It's really long. They end up dismissing the jury, and then they argue in front of us. I do explain to you what the hell is happening, or try my best to. So if you guys want to skip through all this mess that happened before the jury gets back, the chapters are down below. Feel free to jump around and skip wherever you want to, okay? But for those of you guys who are like, I want to see what happened here, because I think it's interesting, I will keep it down here for the rest of y'all. I'm just telling you, it is kind of long, but I do think it's interesting. The judge does start getting pretty frustrated with a Mr. Well, I mean, you know who. Who do you think the judge was frustrated at? Mr. J or Mr. Owen? Owens is going to be reading quite a few lines from a deposition that he had with the witness and with the state being there as well. Oh, God, something in my throat.
Then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder.
Okay, we had another expert explain the difference between general... They talked about adjustment disorder. I remember that.
I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38?
38, line 21. I need time to go through my notes, think about it, process it. But I had other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process on my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7 for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she
That's your position, Mr. Conducting discovery after the jury trial starts.
starts is completely unacceptable to me.
Okay.
So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward, and then you can add to your deposition at that point, if my opinions change after having reviewed further. And then, do you want me to continue reading, or?
If there's portions you want to highlight for me, I mean, I have the transcript. I'm following along with you.
That was the general understanding that we had.
Okay, I don't know if you guys can hear Owens, but this is the deposition of the expert that's on the stand right now. So during the deposition, the expert says that they believe Sarah Boone has generalized anxiety disorder. Boone was previously diagnosed with it. However, she wants to see that maybe it's an adjustment disorder. And then Owens is like, whoa, hold on a second. We can't be getting your opinions in the middle, new opinions from you in the middle of the trial. Like, we need to know what you are saying right now. And it seems like Mr. J is like, okay, well, you know, if she thinks it's adjustment disorder instead, that's something we'll address. And then we'll see, you know, we'll just continue on with the deposition. So that seems like that is what happened. But I don't know, the judge is like making, the tone that the judge is making and like some of the facial expressions, I wonder if he's not agreeing with Owens.
About all diagnoses, all opinions that she may have. And so,
Or maybe he's just annoyed with Owens and Owens is not reading verbatim and Owens is kind of like skipping around.
Pertains to an opinion specifically about post-traumatic stress disorder. And at this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality.
And I like how it's very specific with that. The non-objection Owens, because Owens sometimes, instead of saying like objection and then saying what the objection is, he'll just say, Judge, hold on a second now. I don't think we should be doing this.
Traits or diagnosis of narcissism. The question pertains to PTSD.
PTSD.
all right, page 46,
All right, keep reading. Keep reading, y'all.
line 1, question, okay? Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give any criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15, no. I would have to look back through my notes to see if she fully met the criteria. Question, line 17. Can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19. No. I didn't say one way or the other. I would have to look back through my notes for that.
What are the legal grounds of the objection?
I would not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But under the promises from the state,
What are the legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection?
Judge, I don't know, man. I was just hoping I'd give you that whole entire thing to see if you can figure out what the legal grounds for objection is, because I don't know, Judge. Henderson ain't here right now. Where's Mr. Henderson? I don't know where he is. He might be sitting in the back, maybe.
I understand the backdrop.
I mean, I don't know if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of a change of opinion and I would be allowed to take a second deposition. That's the only thing I know to object to.
I'm not casting blame. I'm just going back over what was asked and what was said. Okay.
Yes. Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not apply.
That's irrelevant for the purposes of this argument.
Well, their discussions and him feeling like it didn't apply.
Okay, as an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Owens?
I'm asking, I don't know if we need to proffer the entire testimony of this witness, because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition before.
Oh, shit. Okay. All right. Well, so basically a proffer, continue asking questions without the jury in there. And then once they know what the witness is going to say in the stand and they're good with it, okay, now let's bring in the jury and let's do that all over again.
She testifies.
May I just proffer?
Yes.
All right, you've been present for all this hearing, yes, doctor?
Yes.
Am I misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
No.
That's it.
Judge, number one, she's given a legal
Jay's like, fine, let me fucking do it real quick. Okay, let me ask the questions. All right, I got this. That's it. You see? That's it.
opinion. Number two, it's a discovery violation.
What is the legal opinion?
That post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did, and that's what experts do.
I would like to have known that, and that was going to be her opinion before today.
Where is that a change in the
You
deposition?
have to read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it and find.
The Kradnick fan club.
I believe it's a discovery violation because I should have been notified there was going to be a change in opinions here today. And we had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of a trial with a new opinion.
What new opinions are different based on what Mr. J.
That is what the judge asked earlier. That is what the judge asked earlier.
With a new opinion.
What new opinions are different based on what Mr. J proffered the testimony is going to be?
I have to ask Madam Clerk to reread the question and the answer from the expert. It's been so long now.
Am I lost, or this legitimately not seem like it has any grounds or makes sense? Recap what is happening right now. I might be confused. Okay, Jen, I will definitely recap. The judge kept asking Mr. Owens over and over again, what are the legal grounds? And Mr. Owens is like, I don't know. Discovery violation? I don't know. Will they call Sarah Boone back after everyone else testifies? I don't know. I feel like it would be good to recall Sarah Boone back on the stand, but I don't know if that's something that they do in Florida in criminal court, if they recall the defendant to testify again. I know that was done in the Johnny Depp trial, but different criminal system. That was a civil case, and then that was in Virginia. When I'm editing, do I have to listen to everything again? Oh, thank God, no. No, I transcribe the video. How long does it take to edit? I don't know. Because, I have to edit it, and then I put my thoughts into it, and sometimes I'm really tired. I try to be as quick as I can, but it could take a couple hours. What takes more time is the video being uploaded to YouTube. So my upload speed kind of sucks. I used to have fiber, and it used to be like, boom, bam, boom. Like, when I did the Amber Heard Depp trial stuff, boom, bam, bam. It was uploaded so quickly. But now I don't have fiber internet anymore. And I'm super sad because the street next to me has fiber. We just don't have fiber. We don't have fiber here. I'm so sad. We need fiber. Judge Wayne probably thanks Kradnick every day for taking his migraine off the trial of his hands. Yeah, probably. Probably. We're waiting for... Now here's Mr. J that we have been waiting for. I mean, we do see the fire with Mr. J when he's kind of fed up with Mr. Owens. Fed up with the Owens. How do I keep my notes? I write the notes on my notepad here, and I try to highlight the stuff that I want to make sure I bring up in the video. Lies. We know Shiro's the one who edits and then uploads everything. He's the executive producer. I had someone that wanted to be my editor to do shorts for me, but if you're not familiar with the court coverage, I feel like it's hard to have someone edit your stuff. I feel like you have to know what's going on and what's important. It's not just like you're just taking highlights and you're just clipping it, right? I don't know. But I had someone that wanted to do my shorts for me, but they weren't highlighting what was important. All right, y'all. So a little recap of this morning. So this morning, the defense has rested their case. We are now in rebuttal. I don't know what y'all thought of Dr. Tanya Werner on the stand. I think when she speaks, I feel like it's easier to listen to the previous expert. She spoke very slowly in a very... I don't know. I would just say there's a difference in the two experts. This expert here, I feel like she went a little bit too quickly, especially with talking about the February 23rd timeline. I think it's also because she could have been just really nervous and maybe didn't super memorize certain things. I don't know. I think maybe she was really nervous, but she went through it very, very, very quickly. I wish she slowed down a little bit. Felt like she was just trying to say it as quick as she can so she doesn't forget. But she talked about basically the same thing that the other two experts talked about, the cycle of abuse and how something that is, if you're in an abusive relationship, both you guys are abusive for 3.5 years, it may not be traumatic for you. It may not be traumatic. Again, talked about control, whether it's financially, the ability to drive. There might be some isolation happening. You don't have access to your family, friends, or access to money by controlling if you work or not. There might be some inequitable power dynamics. So Mr. J is trying to show that with Sarah Boone and George. And again, I feel like he really needs to do a good job at hammering it down because at this point, from what the jury has seen, they've seen extensive injuries of Sarah Boone, and they're like, okay, yeah, she's definitely the battered one in this relationship. Now, whether or not they're going to also accept that George was also the battered one that's in this relationship, Mr. J has to do a really good job at proving that. Whether it's through the body cam or we get to see injuries, medical records of George. I don't think we're going to see the medical records of George. I don't think they included that. Defense decided not to include the medical records, and I don't think the state is introducing it. She recalled the February 23rd, 2020 timeline. Again, went through it pretty quickly, in my opinion. Again, there are inconsistencies with what Sarah is telling people and what she testified on the stand as, for example, the time that they started drinking. It's either noon, it's either 4. Depends on when you ask her. Now, the reason why there is this giant fat recess is because they got to the part where they were asking about Sarah and George while he was in the suitcase. The state asked about PTSD. Her response was, Sarah Boone did not give her enough information to diagnose her with PTSD. Objection, judge. Objection. Actually, I don't know if he even said objection. Did he even say objection, or did he just start standing up and just start talking? The jury was dismissed because the sidebar was very, very long. And I'm like, yes, let me listen to what you guys are arguing about. Dismiss the jury. So we dismissed the damn jury, and then we got to listen to what the hell it was that they were arguing about, and it was pretty gold. Any arguments with the judge, the state, Mr. Owens, I feel like it's always going to be gold, okay? We like hearing from the judge as well. So the issue that Owens has is that he did the deposition of this, or sorry, I think it was the state. They did the deposition of this expert. I think it was done by the state. And the expert said that she believes Sarah Boone has a generalized anxiety disorder. However, she's not sure if Sarah Boone maybe suffers from adjustment disorder from just being in jail. She would have to look at her notes. And Owen's like, oh, no, that's not acceptable. I need to know now because I need to know what the fuck it is that you're going to say at trial. And then so there was some back and forth between the three of them and Mr. J, the witness, and Mr. Owens during the deposition, right? They're trying to figure out, okay, should we just skip this for now? And then if you have something that you want to add on later on, make sure you contact the attorneys, make sure you tell me, right? So there was some back and forth in the courtroom today about that, what it is that Sarah Boone has been diagnosed with. And the judge kept saying, what are the legal grounds? I get it that you're reading from the transcript. I get the history of it, but what are your legal grounds for this? Silence. What are your legal grounds? Silence. So Owens is also saying that there is a discovery violation because he's saying that the witness had a change of opinion. So what was told in deposition is different than what she is saying now. And the judge is asking, okay, what is the difference in opinion? And Owens didn't really answer that. Owens like, you know what? I want to have a proffer. So a proffer is when you're questioning the witness to see, what they're going to say without the jury being present. So they do a proffer and the jury's outside of the courtroom. When they're done with the proffer, they will bring the jury back in and then ask the same thing just to make sure everything's good because they don't want to taint the jury, right? And Owens kind of got, no, not Owens, Mr. J kind of got fed up. Mr. J was like, you know what? Let me do the proffer right now. He does the proffer, asks her some really quick questions about, did your opinion change? What are you going to say about PTSD? What are you going to say about this? Did PTSD relate to the situation that Sarah Boone was in when she left George in the suitcase, right? When she was hitting him with the baseball bat and all that stuff. And so Owens like, see, done quick. There you go. And then Owens is like, Mr. J was like, done quick. Let's go, right? And so there's some back and forth. Judge was like, what is the opinion that's changed? I don't know. Owens couldn't answer that. And then they moved on to the next number 2, which Owens was like, oh, this is a discovery violation. We're going to have to read the whole transcript. And the judge is like, no. The transcript is like fucking 87 pages long. We're not going to read the whole transcript, okay? It's your objection. You have the burden. So give me the page number. Give me the line. And so they started going through the pages. And we're taking another mini break because maybe the judge and Owens and Mr. J, maybe they're talking off camera because they don't want us there. I don't know. They're taking a little mini break right now. So that is where we are at. Owens is essentially saying the expert on the stand has a different opinion than what was said during discovery. The expert, Mr. J, said that if there's a new opinion, then they will let everyone know. Owens is saying, no one let me know. There's a new opinion, no one let me know. That's fucked up. That is what Owens is saying. But the judge is saying, well, what is a new opinion?
Let's just reread the entire proffer, just so that it's a clear soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter, if you
Soup
could
to
be
nuts,
so kind.
alpha to omega. Owens is saying the opinion is different, that he should have been notified per the agreement when in the deposition.
It seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. Then that is an opinion that I needed to know about. And this is a discovery violation based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I asked that the witness be stricken.
I specifically asked you, Mr. Owens, to point out for me I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us.
So Owens is trying to say that there was a discovery violation by the state. The court is now going to conduct a Richardson hearing to determine if there was and what are they going to do with it.
The portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369, Southern 3rd, 1243, at pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing.
And the Richardson hearing is what we had right before the trial started, because the state tried saying that the defense, there was a discovery violation because of the pages of the medical records that were given to them, and they looked very different than what was given to them 2 months ago. So we are now doing the Richardson hearing.
All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition.
You think he's going to strike the entire witness? No. Or maybe just strike the statement? Ooh, and then letting her not talk about PTSD. Oh God, what is he gonna say? What is he gonna say? Oh, hi, Shiro. Shiro's here. Okay, so he says that it wasn't done on purpose. It was inadvertent, so accidentally. However, it does impact how Mr. Owens would have prepared for the trial. So what's going to be the section?
That any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial, although the questions in the deposition as highlighted by the defense so far do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens.
Let's strike.
Because my question is, do you want it struck?
Kind of funny. The judge is like always doing Owens' job. It's like, you know what? Mr. Owens didn't even highlight the right portion, but this is the portion that would pertain. So yeah, we'll go with it. And then Owens, what do you want to do? Do you want to have it struck? I don't know. Owens pretty quiet over there. Hey, close the door. Owens?
On that issue, we'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going to question her about post-traumatic stress, so it's going to come out through my cross from the deposition about what she said, and then it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right.
The judge is going to now allow Owens to conduct a in-court deposition of the witness on the stand. That way, when he does his cross-examination later, he's like prepared for it. So that is what's going to happen.
The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert, as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial.
I think Sarah said that she was 100 pounds at the time of the arrest.
Your objection's overruled.
All right. Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's an asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing, when he got in the suitcase, when she found him, they were enjoying themselves, she zipped him up, they were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or there was an imminent risk of harm that she needed to protect herself.
Can we put your name?
Yes.
The jury is sent away again, and they're going to argue about the expert making an opinion on whether or not there was imminent threat to Sarah Boone at the time that George was in the suitcase.
That's a decision whether or not she had imminent risk of harm or perceived an imminent threat is a question for the jury. This expert can express opinions on science, on medicine.
Okay, so he's saying that her opining about whether or not Sarah Boone felt like there was imminent threat, harm, danger, whatever the fuck it is, that is not something for the expert to decide. That is his argument. And that is something for the jury to decide. Okay?
But not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify. That you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time. It doesn't even come into play. Post-traumatic stress disorder, Bader-Sprouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about Bader-Sprouse syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue
90.703.
of fact in this case because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for Bader-Sprouse syndrome, under the jury instructions under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This
90.703, opinion on ultimate issue. Testimony in the form of opinion or inference otherwise admissible is not objectable because it includes an ultimate issue to be decided by the trier of the facts.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976, 7th 2nd 660 at pinpoint 661. In that case, a psychologist testifies. In the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion, see section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court, I'm just going to ask you to read the question and answer, and I have no further questions of the witness.
Okay, thank you. He's going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Yeah, 100 is tiny. I weighed 100 like 90, high 90s, 100 pounds when I was like in high school. I was like super skinny. It was like really hard for me to put on weight.
Basis.
It was asked and answered.
Overruled. There's a pending objection. I'm allowed the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour for my cross-examination.
We're going to begin your cross-examination after we're done with after the state advises the jury in open court that there are no more questions. Let's go ahead and bring back in our panel.
We also have a Discord. If you guys want to join, feel free. We have a true crime section. We'll discuss this case or other cases. Or if you want to discuss non-true crime stuff, feel free to join the Discord. That's basically where the offline hangout is. If you're not live. I'm not live. Oh man, Mr. Owens in that last objection was kind of funny. So now we're going to be doing the cross-examination of Dr. Tanya Warner. And Owens is going to get into some text messages between George and Sarah and why those text messages were not relevant in the evaluation of Sarah Boone. Long sidebar.
Ma'am,
Too
is
emotional.
it fair to say in your evaluation of Sarah Boone on October the 2nd of 2024 that you felt like the text messages that you received from the state attorney
Objection beyond scope.
Overruled.
are not relevant to your evaluation of Sarah Boone?
Withdraw.
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure. I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the text in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition.
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes, that's
And we discussed
Zoom, zoom, zoom.
that these were the phone records from Sarah Boone's phone.
yes.
Okay. And at that time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
You may.
I have it, if you just refer me to the page.
Just a moment.
My question is at line 3. Your answer begins at line 5.
Let me know if you post the screenshot. I want to see it.
Correct.
And you agree that any...
Permission to watch here based on.
Let him finish. Let him finish.
Well, I'm going on. I'm going to ask another question about the text messages, Judge.
You just said line 5. Approach.
Who's doing the cross-examination? Mr. Owens is doing the cross-examination. We are in rebuttal right now.
Dr. Warner, did that refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
Correct.
And do you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone?
Permission to watch here.
Can she answer the question?
Have her answer the question first.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no?
As I said, it made me aware. That's not my complete answer.
Okay, well, let's
I
talk.
can read my
First,
complete
you said no.
As I said, it made me aware that they had a
Ma'am,
volatile
ma'am.
It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence, was no.
It's not my complete answer.
I understand. I'm going to let you answer that. But when I asked you if there was anything in the text messages that caused you to pause and would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
at the same time, Dr. Warner, at the same time you expressed that they had a volatile relationship.
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship,
Correct?
and this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship, and that she text messaged calling him an idiot, a fucking idiot, for overdrafting her account.
Correct.
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, you need to object. We need to approach.
So we're talking about text messages. She said that the text messages were not relevant to her evaluation of Sarah Boone. She qualified that further by saying that she doesn't know whose phone it was. She didn't know whose number was who, or like who even sent it. Had no proof of that. Owens referred to a text message Sarah sent to George, I guess, calling him a fucking idiot because of the overdrafting. And there was mention of something violent in the text message. I don't know what, though. That would have indicated there was domestic violence. They all of a sudden decided to break for lunch, and we'll continue this after the lunch break. Here is a recap of what happened so far in the morning. If you want to skip to after the lunch, if you want to skip to after the lunch break, timestamp is down below. But it doesn't go straight to Dr. Warner's cross-examination. There is another issue that Mr. Owens is raising. He's like, I want a total dismissal of this case. Even though to the jurors it felt like nothing happened, so much has happened. Oh my God, dude. My notes are too long. Let me try my best. All right, y'all. We are at day 15. Defense has rest. The state is now in rebuttal. We started off with Dr. Tanya Werner, who is a psychiatrist, not psychologist, witness number 15 for the state. And for the most part, she seems to largely agree with the defense's expert. She said that Sarah Boone has alcoholic, what is it called again? Essentially alcoholism, but there's a better way to say it. I don't remember. And Sarah Boone is a battered spouse. I think she agreed about the PTSD as well. I'm not too sure what her stance was on depression, because Dr. Julie Harper, for the defense, said that Sarah Boone suffers from depression, or at least at that time. Now, the thing is that this expert said that she doesn't know if, who the hell dropped the camera? She doesn't know if Sarah Boone suffers from generalized anxiety disorder, or if it's just an adjustment disorder from just being in jail. So I guess like it's something where like you have to take time to adjust to your surroundings, your environment, I think. She did agree with Dr. Julie Harper that Sarah Boone has narcissistic personality traits, not narcissistic personality disorder, but she's got some of the traits. She didn't opine on what those traits are specifically, but Dr. Julie Harper did. And, you know, we thought that was kind of funny because Dr. Julie Harper brought up about, Sarah Boone shared with everyone that she was a straight A student, you know, from like 15 years ago when she was in school. Very interesting, feeling the need to boast about your achievements and letting everyone know that you're kind of special. Again, with Dr. Tanya Werner, the state was able to elicit testimony about abuse. About the cycle of abuse, about how you control the other person in the abusive relationship, how there might be some isolation. But I think what the state was trying to show was that, hey, you know, like, yes, Sarah, an abusive relationship. What about George? Is it possible that men can also be abused as well? And he brought up the inequitable power. So that to me seems to make sense. Like, you know, Sarah Boone had the power, it seems like, in the relationship. You know, she was getting money, she was getting alimony. Oh, by the way, I had it wrong. She was getting $1,000 alimony and $100 in child support. I don't know why I heard $1,000 alimony and $1,000 child support. I'm sorry. I listened to it when I was editing yesterday and I was like, oh, fuck, I was wrong. I thought she was getting $2,000 even though the records didn't reflect that. So she was getting $100 in child support. I had that incorrectly. But, you know, it seems like Sarah Boone had, you know, some sort of power in the relationship, although I don't disagree that when there was physical abuse between the two of them, that it was probably Sarah Boone that had more damage. But then again, I don't have a complete picture, so I don't fucking know, right? But That's all that's been shown to the jury so far, because we haven't seen George's medical records, George's pictures, or anything like that. That's why I'm saying that if Mr. J wants to truly convince a jury that George was also the one who's being abused in the relationship, that he was also a victim, so you could be an abuser and a victim in a relationship, right? He needs to do a really good job at showing that, because so far right now, I don't think it's convincing the jury that we should feel sorry for George and that he was also a victim, because of all the pictures that were shown to the jury of Sarah Boone and her injuries. So I'm not saying that George isn't a victim, but I'm saying that Mr. J really needs to show that to the jury for them to buy this, right? Although I don't think it has really anything to do with whether or not what happened to George was justified, but I think it might help the jury in some way in making their determination. I don't know. I guess, like, even though you're not supposed to be persuaded by emotional, strings, but at the same time, people are humans and sometimes they can't help it, right? But like I said, I don't think it's justified what Sarah Boone did. The expert went into the February 23rd, 2020 events. Seems like she was really nervous, had initially a hard time recalling, but then she was able to look at her notes. So she went through very quickly what Sarah did, and then got into the part where George was already in the suitcase and Sarah Boone and George were having a fun time. They were laughing. And then at some point, Sarah Boone got really angry. Now, she said that at the time, Sarah Boone did not give her enough information to diagnose her with PTSD. And that's where we had the long ass motherfucking objection, okay? We had the objection, the sidebar, and then we dismissed the jury because we're going to discuss this in open court. I'm like, yes, because I want to hear what they're discussing about. So Owens had an objection, but I think the thing with Owens is that he might seem incompetent because when he is objecting certain things or when he's making his arguments, he has a tough time at pinpointing out the evidence to support his arguments and maybe even eloquently telling everyone what it is he's objecting to and how, if he's going to refer to some lines in a transcript, what lines support his objections. And I think that's why there's a lot of back and forth between Owens, judge, and the state, because the judge just wants to be like, boom, boom, boom. And Owens is kind of like all over the place sometimes. So Owens did have an objection, and he wanted the witness to be stricken completely because he claims that there was a discovery violation, that the witness, what she said during deposition, apparently the witness had new information or a new opinion, and that new opinion was testified to in court today. Owens is like, well, we agreed on if you had a new opinion, you were going to notify the attorneys. It seems like you didn't do that. And so right now, it's not fair to me that we're in trial right now and you're giving me this new information because I have to prep my witnesses and blah, 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 and whatever it is. So that's why I think Owens does get a rebuttal. I'm assuming based on what I'm hearing that he does get a rebuttal. So that was the major issue. There was a lot of legal back and forth because the judge kept saying, what are the legal grounds? What are the legal grounds? Owens couldn't answer. And then the judge was like, okay, well, what is the difference in opinion? Mr. J got frustrated and was like, you know what, fuck it. Let me just do the proffer really quick to see if there really is an issue. The state does a proffer, and it seems like the answer was a little bit different, which is an issue for the judge. And then Owens moves on to the next part. He was talking about, again, discovery violation, right? And so that's when Owens is like, I'm going to have to read the whole transcript, judge. And judge is like, no, you're not reading an 87-page transcript. We're not sitting here. We're not fucking doing that. This is your objection. It's your burden. So we need to know what is your objection to, give us your grounds, and then, back it up, right? We went to another break. All right, so we're back from the break, and they're having the clerk of court going through the transcript again and rereading the proffer and then rereading some other stuff. And then that's where we got to hear the phrase soup to nuts and alpha to omega. So I guess meaning from beginning to end. I'm going to start using that from now on. So again, Owens is reiterating that if she had a difference in opinion, she should have told me, not surprise me in trial. That's not fair. That's not fair. And so Jay is like, well, I think you're misinterpreting what's happening here. You're misinterpreting the testimony. She's going to say that battered spouse syndrome or PTSD is irrelevant at the time of the suitcase thing because of what Sarah Boone told the expert. So again, lots of back and forth with the judge and Owens. Judge is like, pick out a portion of the deposition that is going to support your argument. And Owens was like kind of like struggling to do that. I think he finally chose a page. I don't know. They're going, I don't know if he actually did pick out, I think he did pick out an excerpt. And then the judge was like, oh, this is not even the correct excerpt, but I found one for you. And there you go. Here's your argument. All right. Where else are we now? So the judge said that to strike the witness completely, that is a very extraordinary, kind of like an extraordinary thing to do. That's very harsh. He even said it was draconian. So we're not going to strike the witness completely. Do you want to strike the question, the answer? Owen's like, no, I don't want to strike it actually, because I want to be able to use this on cross-examination. And so the judge was like, okay, well, in order to remedy the situation, I'm going to let you do a mini deposition, an in-court deposition right now with the expert. So Owens is talking to the expert. He's doing his mini deposition. However, when he's doing it, he's very aggressive and he's kind of like attacking the expert. I mean, rightfully so, but you know, there's better use of your time. He's attacking the expert for, you know, why didn't you tell me there's a change? Why didn't you tell me there's a change? And that kind of ends it there. And the judge was like, Owens, this is your chance to do a deposition. Is there anything you want to find out from this expert? Is there anything you want to ask her? That way, when you do your cross-examination, you won't be blindsided, right? And so Owens said something about hiding the ball. I don't know. The judge was like, no, there's no hiding of the ball. And then he continues doing his deposition, asking the witness on the stand, the expert, Dr. Warner, about, okay, so did you see if, you know, does Sarah Boone have narcissistic personality disorder? The expert said, no, but I found traits. What about alcohol use disorder? Yes. What about anxiety disorder? No. However, in the deposition, she wasn't sure if Sarah Boone suffered from anxiety or adjustment disorder. She was leaning towards adjustment disorder because of the legal situation with Sarah Boone being in jail. She said that Sarah Boone suffers trauma as it relates to domestic violence, intimate partner violence, as reported by Sarah Boone. It's funny that she like threw that in there. Yeah, like she said that Sarah Boone suffers from it, but as it was reported by Sarah Boone. So again, it's like, you know, we only hear from Sarah Boone's perspective of it, right? We're only getting one side of it. So based on what Sarah Boone says, yes, it seems like she does suffer from this. Does Sarah Boone suffer from psychosis? Nope. Does Sarah Boone suffer from acute stress disorder? Nope. How about intimate partner violence? Yes, she said. There was enough history, enough volatile history between the two of them, and that it would relate to battered spouse syndrome. All right. So the judge says that he will not strike the expert. So at this point, because, you know, there is an accusation of a discovery violation, the judge had to hold a Richardson hearing. And if you guys are like, oh, Richardson hearing, that sounds familiar, it's because they had to do the Richardson hearing in the beginning of trial or before the trial started, because the state accused the defense, not the judge, of a discovery violation because there was these medical records that were sent over that looked different than what was sent over 2 months ago. So there was a Richardson hearing for that one. So now we're doing a new Richardson hearing, and the judge was like, okay, well, I'm not going to strike the expert because, you know, that's a very old way of doing things. However, he did see that there was a discovery violation.
Hey, everybody, thank you so much for watching.
It was inadvertent, though, so it wasn't done on purpose or anything like that. But this did affect how, you know, Owens, it did affect Owens' defense for the trial. So as a remedy for that, he let Owens do the in-court deposition, which I already mentioned earlier. And then we continued on with the very short direct examination, but the direct examination already kind of ended. And so instead, Mr. J, after having the jury wait for so long, we all went back into court, and Mr. J just had the court reporter read back what was previously stated. Oh, yes. Okay, sorry. We're not in cross-examination. Rewind it back a little bit. We're still in direct examination, and it was mentioned that, you know, why is it that Sarah Boone didn't suffer from BSS or PTSD during the time relating to the incident? And the expert was like, oh, it's because Sarah Boone was describing that they were having a good time, that, you know, they were playing hide and go seek, and that she found him. He was enjoying himself. You know, they were having a good time, not consistent with having imminent risk of harm. Owens objected to that because he didn't like the imminent risk of harm. He says that The jury makes that determination whether or not there is an imminent threat, not the expert. And so there's some back and forth in there. And then the judge overruled the objection and sided with the defense. He cited 90.703. So the judge said that the psych's testimony is not legal conclusion. They didn't opine on the guilt or the innocence, and that an expert can render opinion that an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact, and the trier of fact is the jury. So there was an objection, and that was overruled. The judge sided with Mr. J. And then we had the cross-examination, and again, cross-examination kind of choppy because we had some long sidebars. And we're in the text messages right now. So text messages, the expert said that she did not think the text messages were relevant to the evaluation of Sarah Boone. And Mr. Owens is basically making a point as to like, why not? Why would the text messages not be relevant to your evaluation of Sarah Boone? Apparently the text messages was Sarah Boone calling George a fucking idiot for overdrafting and mentioned some domestic violence in the text message. Now, someone in the chat was like, why is Owens fighting on her about the text message if largely the two experts agree? So they agree that, battered spouse syndrome. They agreed about, PTSD, about the intimate partner violence. They agree about, what else was there? What am I missing? The alcohol use disorder. So it's like, why is Owens kind of like saying, oh, you didn't look at this to make your determination? So I get that part. We'll see where Owens is going after the lunch break. Okay, we're back for the shit show sidebar. Now, if you guys want to go straight to the witness testifying in the stand, timestamps over here. Otherwise, Owens rehashes the same argument as what he argued this morning. The judge entertains it, but the judge gets really, really fed up with Owens. Oh, gosh. He goes back and reads the transcript again. It's quite lengthy. I won't include it, but here is his argument.
That was our understanding. I've been ambushed by a new opinion that I was not made aware of by any kind of report. I was not notified by Dr. Warner. I was not notified by the state attorney, William J. I first heard about the opinion when she testified to it, and I objected to it, relating to imminent threat, the ultimate issue of fact. I move for a total dismissal for prosecutorial misconduct.
Denied.
Oh my God, that was the fastest denial ever. Holy shit, man. Alec Baldwin? Carrie Morrissey? Hello? Excuse me? Mr. Owens? Mr. Owens tried. Mr. Owens tried. Oh my God, that was such a quick ass denial. It was so fast. The judge's face. Mr. Owens has a penchant for getting things denied and then asking for it again. It's like anytime he gets something denied, be sure that he'll ask for it again.
I move for a total dismissal for prosecutorial misconduct.
Denied. And here's the other reason it's denied. Page 38 of the deposition, specifically that you made reference to, starts at page 21, line 21. The question preceding that is important. Question 14. So, from my understanding, when you just said was, yeah, I agree with general anxiety disorder that she had been diagnosed with. Answer, no. I said it would be generalized anxiety disorder versus adjustment disorder, and that I hadn't had time to fully formulate that opinion out. This entire conversation pertains to those two issues. Anxiety disorder and adjustment disorder. Has nothing to do with PTSD, nothing to do with battered spouse.
But Judge, we go on, and I see what she's doing. That she's saying, hey, I got jammed up, I had a deposition.
The judge also reiterated this. I think this is like his third time saying this.
Yesterday, I didn't really have time between the evaluation and the deposition 2 days later. She had a deposition in between to really think about it, really review my notes. So as a catch-all, I said on page 40, if you have other opinions or other diagnoses after she has more time to think and review the paperwork, then obviously that creates an issue. So yes, that was initially what she was talking about specifically, but I realized what she was saying was she was going to have to reflect on a lot of these opinions. So
That's respectfully, sir, that's not what it says. That's specifically in line with the anxiety disorder versus adjustment disorder. That was the entire topic that was being conversed with. Now, later in the deposition, there are references, as I believe that I identified previously. Give me a moment. On page 59, line 22, question is asked, okay, and do you intend on expressing any other opinions other than what we've spoken about here today? Line 25, no. I will answer whatever questions I'm, moving to page 60, line 1, asked. Page 60, line 11. Well, let me just start with 2 because it gives it more context. Question, well, I'm asking now. I mean, you're the expert. I'm not. You're the one that's evaluated her. You're the one that's given her the test. I don't know the field like you do. You know the field. I understand you've said, hey, I want to think some more about, hey, I want to think about this some more. I want to review my notes. Some more to see if, but in terms of right now, without any further reflection, without any further answer, yes sir, question, reading of the notes, any other opinions that you think you could express in any form or fashion with all this experience, almost 1,000 jury trial or 1,000 trials you've testified as an expert. Anything else that comes to mind that may be an opinion that you might express in Sarah Boone's case? Answer. Anything else that I'm asked with regard to her diagnosis come into play with regard to her case, I guess? Question. What other opinions do you believe you're qualified to express as it relates to Sarah Boone and the facts and circumstances relating to this case? Anything with regard to her diagnosis, I guess. 61. Of those 4 things we mentioned, line 2, correct.
And Judge, the 4 things were mentioned were related to the anxiety disorder, the narcissism, the battered spouse, the alcohol use disorder, which are in pages 58 to 59. But the overall thrust of that was any other opinions that were expressed. That was in good faith what we were doing. I would have, like I said before, I would have never taken her deposition. Once she said I hadn't finished my analysis and I may need additional information, just like he said the other day, Dr. Harper, if you get those additional medical records, Mr. Owens, about George Torres and give them to Dr. Harper, then I'm going to want to take her deposition again. The same rules apply. Why would I take her deposition when she hasn't finished her
Because the court ordered you to take her deposition because there were concerns about being able to have all of this done prior to trial. And you had concerns about what she was going to testify to. And the court set a scheduling order as to when, how, where, and the deadlines for those depositions to be conducted.
That prosecutor should have let me know. If he was going to ambush me at trial, I should have known beforehand about a new opinion that Dr. Warner was going to express, especially related to that.
That prosecutor, wow, not even referring him by name anymore. That prosecutor.
And the courts addressed that. The court did exactly what was required by binding precedent by the 6th District Court of Appeal and held a Richardson hearing. Yep. Analyzed the 3 factors as required by Florida law with regard to those and gave you the opportunity as a cure. Now, with regard to your request to strike or dismiss the case due to prosecutorial conduct, the case law by the 3rd District Court of Appeal filed April 10, 2024, State of Florida versus Denninghoff, Deninghoff, and I can provide you a citation momentarily, states that dismissal is an extreme sanction to be used with caution and only when a lesser sanction wouldn't achieve the desired result. Specifically, dismissal of an information or indictment is an action of such magnitude that resort to such sanction should only be had when no viable alternative exists. There were multiple viable alternatives, including but not limited to my request, an inquiry of whether or not you wanted that struck, and the instruction to strike that opinion, which you demurred and said, no, I want it for cross-examination. And I gave you the opportunity twice to depose her here in open court, which I oversaw with regard to any opinion that she had based on the proffer or any other opinion that she would be offering today. For those reasons, the court is not going to exercise its discretion and strike due to the extreme nature of striking a criminal charge and for the adequate remedy that has been provided to you.
Judge, I'd like to add on page 79 that Dr. Warner claims that Sarah said he put his two fingers out and I hit them with a bat. So there was rule of completeness. But for him to say that that's not standard operating procedure when you're taking a deposition of an expert.
Mr. Owens, I've ruled, sir. I understand. I understand your position. However, the questions that were specifically asked, which gave rise to this, specifically pertain to opinions of PTSD. I'm not going to rehash any and all of those things. The record speaks for itself. The court has ruled. Your motion for dismissal of the charges is denied. For the record, the citation that the court relied upon with regard to Denninghoff is located at 388 Southern 3rd 10055, located at pinpoint 1057, Florida, 3rd District Court of Appeal, April 10th, 2024. With that, are we ready to bring back in our panel?
Oh, but Owens is not done yet. There is more. And Owens does a lot of reading from the text. And I think the judge is like, why are we reading this entire thing?
Whether the testimony of the expert is a permissible factual conclusion or the impermissible application of a legal standard or definition to a set of facts is sometimes a fine distinction involving a large measure of discretion with a trial judge. For example, the admission of expert testimony that certain investments, it goes on. However, the witness expresses an opinion about the intent of the accused. The opinion, this is important, one of the important sections. However, if the witness expresses an opinion about the intent of the accused, which Dr. Warner did, the opinion has not been permitted. The distinction drawn by the courts as to when this type of opinion testimony is admissible are often not clear. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. This expert testimony regarding substantive legal principles may not be helpful to the jury and may create confusion if an expert testifies in a manner that is different or even in conflict with the testimony of an opposing expert.
But the citations, respectfully, Counselor.
If I could finish.
Respectfully, Counselor. The citations that you're referring to are not at issue. Fluellen. Error to permit arresting officer to testify that a quantity of cocaine possessed by appellant indicated that he possessed with intent to sell, which is a specific element of the charge in that case. Gamble. Officer's expert testimony with the amount of drugs found in defendant's possession was inconsistent with personal use and therefore intended for sale was inadmissible. 644 Southern 2nd 1376 by 4 Gamble and Fluellen 703 Southern 2nd 511. The Dinkin case that I read says this is acceptable. If a psychologist or psychiatrist can testify that someone is not mentally defective or was mentally defective, that's on all fours with based on what the defendant has said to this expert. She was not in imminent fear. Now, I don't remember exactly what was said, but it was along those lines, based as looking all those things, the totality of the circumstances of what, in my evaluation, on or about October 2, that the defendant had said to me as the expert, it's not imminent fear. That opinion is not inadmissible per the case law under Dinkins.
Judge, can I read a little bit more?
If you're just going to be reading from the treatise, I've already
Can I be reading the whole page, please? 87 pages. Let me read the whole thing.
read it.
Okay, well, I just want to make mention, because it's talking about does not prevent a witness to testify about legal conclusions or express opinions on questions of substantive law. And I was about to finish this section when this testimony, and I'm on page 947, this testimony may also interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. As we know, we're going to do battle over the jury instruction on justifiable use of deadly and non-deadly force. The testimony from Dr. Warner, and I wrote it down, she said based on what Sarah Boone told her, she was not facing imminent risk of harm. That invades the province and function of the trial judge to determine the applicable law. Sarah, the testimony...
Okay, give me a second. I kind of want to go back to what the judge said just for a second, and then I'll be back to where we are.
By 4 Gamble and Fluellen. If a psychologist or psychiatrist can testify that someone is not mentally defective or was mentally defective, that's on all fours with based on what the defendant has said to this expert. She was not in imminent fear. Now, I don't remember exactly what was said, but it was along those lines, based as looking all those things. Opinion.
We know we're going to do battle over the jury instruction on justifiable use. Test opinions on... Can I read a little bit more?
If you're just going to be reading from the treatise, I've already read it.
Okay, well, I just want to make mention, because it's talking about does not prevent a witness to testify about legal conclusions or express opinions on questions of substantive law. And I was about to finish this section when this testimony, and I'm on page 947, this testimony may also interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. As we know, we're going to do battle over the jury instruction on justifiable use of deadly and non-deadly force. The testimony from Dr. Warner, and I wrote it down, she said based on what Sarah Boone told her, she was not facing imminent risk of harm. That invades the province and function of the trial judge to determine the applicable law and to instruct the jury otherwise, which we haven't even done yet. You haven't made findings of law about which instructions apply. That's what she did, Judge.
Your objection's been made for the record. The court.
I mean, the judge is reading it verbatim that, oh God, I don't know where it is. There's so many. Opinion on ultimate issue. Testimony in the form of opinion or inference, otherwise admissible, is not objectionable because it includes an ultimate issue to be decided by the trier of fact. So it seems like that is something that the jury will decide. But Owens is saying that, like, oh, well, I don't know. I get sort of where Owens is coming from. He just wants to make sure that the expert saying Sarah Boone didn't have imminent fear, that later on it won't fuck with the jury instructions on whether or not there was justifiable use of deadly/non-deadly force. Because one of the elements of that is like, oh, you have to feel like you're in imminent threat or fear of your life or something. But I mean, how I'm understanding it is that, well, the juries are going to be the ones that ultimately decide that.
Court previously ruled on this matter. I appreciate the additional argument, but the court's reliance on Dinkins remains.
Do you appreciate the additional argument, Judge? Do you? Do you really? Tell us how you feel. Tell us how you feel, Judge.
Just because 9703 speaks for itself. So your objection is overruled as to that issue. Anything else we need to address, Mr. Owens, before we bring back in our panel?
No, sir.
State?
Nothing. Thank you, Judge.
Okay, let's bring back in our panel.
Oh, man. All right, welcome back from the Owens Show. Now we are going to finally get into the cross-examination of Dr. Warner. And here are the highlights of the cross-examination done by Mr. Owens.
Actually, the majority of my work is in patient care. I work 7 days a week on the crisis stabilization unit, actually treating patients.
You work 7 days a week.
Yes, sir.
So, as a forensic psychiatrist doing forensic work, the majority of your work in that area is in the field of competency to proceed and guardianship evaluations.
As a forensic psychiatrist, correct. As a psychiatrist, I work 7 days a week on the crisis stabilization unit.
And where is that unit?
It's located in Lake City, Florida.
So you work there 7 days a week.
Yes, sir.
Crisis stabilization unit.
And then you also do this forensic psychiatrist work doing competencies to proceed and guardianship evaluations.
That's part of the what comes under the umbrella of my forensic work, yes.
Crisis stabilization unit, CSU, provide the community with 24 hours, 7 days a week, year-round service to individuals who are experiencing behavioral health crisis, requiring emergent stabilization that cannot wait until a regularly scheduled appointment.
That's the majority of your forensic work.
Yes, that's the majority of that's the most common cases that we're asked to.
And then next in line would be sanity at the time of the crime.
Yes.
So you would make a determination and submit a report to the court as to whether or not a defendant, an accused, is legally sane or not at the time of the offense.
Yes, that's correct.
I think I would have to defend Mr. Owens. I think Mr. Owens is doing a better job than Elaine. I mean, Elaine's sidebars were also really bad too. So maybe if there's some Owens sidebars that are released in the future. But I think he's doing a way better job than Elaine. Elaine was just kind of like, I don't know. She must have skipped breakfast on some days or something. I don't know. Elaine was a weird one.
Do you believe that she suffers from a generalized anxiety disorder?
No, sir.
Now, you're aware that she was previously diagnosed, prior to you evaluating her, she was previously diagnosed with a generalized anxiety disorder.
She told me that she had previously been diagnosed. I did not see any medical records with that diagnosis in it, but she told me that she had previously been diagnosed with that.
Did you attempt to secure any other records to us?
Proper. Sustained.
Did you
Ooh, I'm surprised he didn't cut her off. I'm surprised he didn't say, just say yes or no, ma'am. Don't need to elaborate.
diagnose her with an adjustment disorder?
I did diagnose her with an adjustment disorder.
Do you believe that if she was diagnosed with a generalized anxiety disorder, it's really not that, it should be an adjustment disorder?
A lot of the symptoms overlap for the two diagnoses, and we see that quite often, that the different diagnosticians or physicians come up with different diagnoses based on a conglomerate of symptoms. So it's not uncommon for the two diagnoses to overlap based on the symptoms.
Do you agree back on October the 4th, 2024, when I took your deposition, that you could not make up your mind at that time whether she suffered from generalized anxiety disorder or an adjustment disorder?
I had not made a clinical decision at that time. I hadn't reviewed all of my documents at that time.
When did you make a clinical decision that she suffered from adjustment disorder as opposed to generalized anxiety disorder?
It was probably within the next week when I was reviewing all of the, going through all of the documents in her interview more thoroughly.
When I took your deposition on October the 4th, you had questions, in all honesty, about whether or not you felt like Sarah Boone suffered from a generalized anxiety disorder versus an adjustment disorder.
I was leaning towards adjustment disorder secondary to her being in the correctional setting, and I think I said that in my deposition. I didn't know that I had enough information from her because I only had information from her. I didn't have anything in the medical records to support generalized anxiety disorder. So I wanted to review that.
I'm just learning it now as you testified here today.
Sustained.
She has a narcissistic personality disorder trait.
A trait, one trait.
Correct.
Do you agree a lot of people have one trait?
Yes.
Okay. A lot of people have a grandiosity trait
Yeah, that's correct.
that are not narcissists.
But I never said that she was a narcissist.
In a
Is it
correctional
your opinion
setting.
that Sarah Boone has alcohol use disorder?
Yes, that's correct.
Is it clear to you that Sarah Boone was involved in a violent relationship with George Torres?
Yes.
Do you agree that there was a violent cycle that occurred during that 3.5-year relationship that Sarah Boone had with George Torres?
It's been described that way, yes.
Would you describe it that way?
It's been described that way to me, yes.
Do you agree that George Torres was the abuser and Sarah Boone was the victim in that?
It was a volatile relationship. In the police report, her ex-husband actually describes her as being the aggressor.
I'm going to show you.
Oh, wait. Wow. Okay. Okay. Because I was like, that's what I was waiting for. I was waiting for her to be the one because she mentioned the police report. She mentioned the Brian Boone in a police interview. And I'm like, oh, I wonder if she's going to talk about Brian Boone and how he talked about Sarah Boone and their relationships. I was hoping for it to come through her. But man, could you have expanded more on that? Please, more.
Would you agree that Sarah Boone suffers from battered spouse syndrome?
I do.
Now, Owens does proceed to show her the big blow-ups of Sarah Boone and her injuries and asks her, oh, have you seen this? Have you seen that? And she's like, no, I haven't seen these pictures before. I haven't seen that one before. And once we're done with that, then we go back to redirect with Mr. J.
Everything that you just talked about with Mr. Owens, does that change your opinion about whether or not battered spouse syndrome is applicable to the facts as Ms. Boone relayed them to you about this incident?
No, not at all.
And why is that?
Yes. So based on my interview with her, the way that she described the incident to me, and that they were laughing and having a good time, it didn't play into relaying any kind of triggers or any kind of trauma.
And I'm showing you what has been marked for identification purposes by the defendant as I. Does this photograph inform you as to what happened?
No.
Does it inform you as to who was the aggressor?
No.
H for identification, same questions. Does it inform you as to what happened?
No.
Does it
Oh, is he using Owen's exhibit right now? Owen's like, don't be touching my Federal Express exhibits.
inform you as to who the aggressor was?
No.
Same questions for G.
No.
F,
No.
E, would you consider somebody's alcohol use and level of intoxication in evaluating the credibility of them as a historian? And you were asked about whether or not you did any testing for post-traumatic stress disorder.
Correct.
And you didn't.
Correct.
You already indicated, however, you believe that Ms. Boone meets the criteria for battered spouse syndrome.
That's correct.
Would you agree that simply because somebody is mentally ill and meets the criteria for diagnosis such as schizophrenia, bipolar, any of those psychotic or mood disorders, that doesn't necessarily make a person legally insane?
Correct. The two aren't equal.
Likewise, even if somebody meets the criteria for battered spouse syndrome, does that mean every action they take against their intimate partner is justified?
Correct. That's not it. They wouldn't be equal.
So even if you do have battered spouse syndrome, even if you are in an intimately violent relationship, that doesn't necessarily mean any action you take against your partner is justified.
That's correct.
So far for the trial, I've been doing the videos in I've been doing the trials in one day. However, today was very extensive because in the second part of the trial, we had a lot of evidence coming in from the state where there's body cam footages between Sarah, George, ones that we haven't seen, portions that we haven't seen, 911 calls, plenty of them, and then videos that Sarah herself filmed between her and George. So that is a whole separate video because sometimes 4-hour videos uploading on YouTube will take forever. I don't know. I'm trying to experiment to see if this might be better. So this one is segmented to a second part. If you guys haven't seen it already, definitely go to the part 2. Okay. All right, guys. I appreciate you guys being here.